Hello and welcome to Verdictum. This is Kanchan and today I am going to explain to you a few interesting judgments of last week from the Supreme Court. The bench of Justice Surya Kant and Justice C.T. Ravi Kumar, while dealing with an SLP, held the relief of anticipatory bail is aimed at safeguarding individual rights. The tightrope we must walk lies in striking a balance between safeguarding individual rights and protecting public interest. The appellant, a long-time landowner in Gurugram, alleged that the respondents forged the sale deed and GPA documents. They also filed an FIR at the Badshahpur police station. Concerned about the potential arrest, the respondents sought anticipatory bail from the additional sessions judge, but it was denied. The respondent then approached the Punjab and Haryana High Court for anticipatory bail, which was granted. Dissatisfied, the appellants approached the Supreme Court to challenge the High Court's decision. Talking about the situation of land mafias forging documents and cheating innocent people, the court said land scams in India have been a persistent issue. Organized criminal networks often plan and execute these intricate scams, exploiting vulnerable individuals and communities. These land scams not only result in financial losses for individuals and investors, but also disrupt development projects, erode public trust, and hinder socio-economic progress. Accordingly, the Apex Court allowed the appeal, set aside the order of the High Court, and directed the Commissioner of Police to constitute an SIT to investigate into the matter. The two-judge bench by Justice B.R. Gavai and Justice J.B. Pardiwala, while dealing with the matter arising out of acquisition of land under the National Highway Authorities Act 1956, held that if any disputes arises as the apportionment of the amount or any part thereof or to any person to whom the same or any part thereof is payable, then the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction. A central government notification to acquire some land for expansion of a highway in Mau. According to the provisions under Section 3G of National Highway Authority Act 1956, compensation was determined to be paid to the landowners. Both the respondents and the appellants were landowners of the land in question. One of the respondents raised an issue regarding the apportionment of land between the respondent and the appellant. Section 3H of the Act 1956 requires the competent authority to determine the share of the landowners in the compensation. The apportionment report was in favor of the appellants. The respondents challenged the same by filing a petition before the district magistrate invoking Section 3G of the Act. The district magistrate granted higher shares in the favor of respondents towards compensation. The order by the district magistrate was challenged before the single judge and division bench of the Allahabad High Court and dismissed twice, and hence the appeal was preferred before the Apex Court. The main issue to determine before the Supreme Court was the powers conferred under the Act. Regarding competent authority, the court said that the legislature has thought fit to confer powers upon the principal civil court of original jurisdiction to determine the dispute arising as to the apportionment of the amount. The actual rule for apportionment has to be formulated in each case so as to ensure a just and equitable distribution of the total value or compensation among the persons interested in the land. The court held that we fail to understand on what basis the High Court in its impugned order has observed that the district magistrate is competent to examine the order passed by the special land acquisition officer and decide the dispute as to the apportionment of the amount. Accordingly, the court allowed the appeal and set aside the order of the district magistrate. The bench of Justice S. Ravindra Bhatt and Justice Dipankar Datta held, we hold at this stage the complainants have no right of audience before this court and even the High Court, having regards to the nature of offence alleged to have been committed by the appellant unless, of course, a situation for compounding of the offence under Section 420 IPC and the permission of the court arises. The appellant, an owner of immovable property, entered into 3 agreements with the builder to redevelop it. The agreement stated that the builder would construct a multi-storied building with the appellant owning the 3rd floor and the upper floor, along with 55 lakh rupees. The builder entered into an agreement to sell and purchase with the complainants allegedly paying him rupees 11 lakh. Complainants made additional payment of rupees 35 lakhs to both the appellant and the builder, but failed to meet the agreement terms, leading the builder to file a civil suit seeking cancellation and forfeiture of rupees 13 lakhs. The apex court noted a disquieting trend emerging over the years, which has gained pace in the recent times, necessitates this opinion. It has been found by us in multiple cases in the past several months that upon FIR being lodged inter alia under Section 420 of the IPC 1860, judicial proceedings initiated by a person accused of cheating to obtain orders under Section 438 of the CRPC 1973 are unwittingly being transformed into process for recovery of the quantum of money allegedly cheated, and the court driven to impose conditions for deposit of payment as prerequisite for grant of pre-arrest bail. The court considered it appropriate to remind the High Courts and the Sessions Court not to be unduly swayed by submissions advanced by the counsel on behalf of the accused in the nature of undertakings to keep in deposit, repay any amount while seeking bail under Section 438 of the CRPC, and incorporating a condition in that behalf for deposit or payment as a prerequisite for grant of bail. The court, while dismissing the matter, noted, under the circumstances we hold that the High Court fell in grave error in proceeding on the basis of the undertaking of the appellant and imposing payment of Rs 22 lakhs as a condition precedent for grant of bail. Till such time further orders are passed by the High Court, the appellant's liberty shall not be infringed by the investigating officer. A bench comprising Justice S. Ravindra Bhatt and Justice Dipankar Datta held that the investigation and the follow-up steps are not so patently and unobstructively defective or erroneous that allowing the trial to progress might cause a miscarriage of justice. It is no part of the business of any of the courts to ascertain what the outcome of trial could be, conviction or acquittal of the accused, unless the prosecution is shown to be illegitimate so as to result in an abuse of power of the process of law. It would not be proper to scuttle it. In this case, a complaint was filed by respondent number 2 against the 7 accused, including the petitioner under Section 406, 420, 506 and 120B IPC. The police report dated February 14th invoked the charges of these sections of IPC against the petitioner. The principal accused is the sister of the petitioner. Respondent number 2 in a statement stated that she paid a sum of Rs 45 lakhs to the principal accused for the purpose of establishing a pharma company that would be engaged in the manufacture of Ayurvedic medicines. It was also alleged that all the accused, including the petitioner, had assured the second respondent with the objective of carrying out the criminal conspiracy. Upon the charge sheet being received, the criminal court took cognizance of the offence and thereafter charges were framed against the accused by the CJM, Kurukshetra, on July 18, 2022. Such order was challenged by the petitioner under Section 397 CRPC. The Additional Sessions Judge, Kurukshetra, dismissed the revision due to lack of merit on September 27, 2022. The petitioner then approached the High Court under Section 482 CRPC, challenging the orders passed by the CJM and the ASG. The High Court, in its order dated November 11, 2022, spurned the challenge and declined interference, resulting in dismissal of the proceedings initiated by the petitioner. Thereafter, the petitioner approached the Supreme Court. The bench looked into the evidence and contents of the charge sheet and found that sufficient evidence is made out against the petitioner. Further, the court looked into the powers under Section 482 CRPC and placed reliance in the case of Amit Kapoor versus Ramesh Chandra. The court held that the principal accused to cheat and defraud the second respondent persuade us to record the involvement of the petitioner. Howsoever, limited cannot be ruled out at this stage, and therefore the trial ought to be permitted and proceeded, and she obliged to stand trial. For the reasons aforesaid, we uphold the impugned judgment and order of the High Court dismissing the petitioner under Section 482 CRPC. The trial court may proceed with the trial uninfluenced by any observation made in this judgment and order, which is for the purpose of the decision of the appeal. The court, while not taking any action and dismissing the appeal, held that Section 180 of the IPC gets attracted only if a statement is refused to be signed, which a public servant is legally competent to require the person making the statement to sign. Thank you and keep watching Verdictum, the dictum of truth. Subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with the latest legal developments.